So at this point, I think if you each want an opportunity to complete your arguments, it would be appropriate.
Thank you. Just a few points. First of all, I thought I heard a suggestion that the constitutional issues are for the courts and maybe not for the commission. And I think it's true that as the Supreme Court said in the I think it's the 1999 advisory, the commission doesn't have the authority to interpret the Constitution or to use its regulatory power to interpret the Constitution. But of course, you're bound by the Constitution. Article 6, Section 1, we all are. It's the supreme law of the state. The 1999 advisory opinion, I think, reiterates the preeminence of the Constitution. And for that matter, the Administrative Procedures Act, which is the basis for anyone seeking review of a final order of the commission, provides a number of factors that a Superior Court judge would consider, and one of them is adherence to the Constitution. So it's the elephant in the room. You can't ignore it. And you can't ignore what the court has said in this series of cases about the constitutionally devised process for judicial selection or for selection of any officer. So I think it would be a mistake to focus only on the regulations, which may say something, or I think do say something that's inconsistent with the Constitution, but to follow the exemption, which I think is consistent with the Constitution, which would allow for the applicant here. Another point I wanted to make, and we haven't really talked about it at all in the hearing, but it's pretty prominent in my filings anyway, is the 2000 article by Jeffrey Tights, former representative, which is in the appendix that I filed. And the reason that's in the appendix is because at the time of the controversy about Justice Lynch-Prata, Jeffrey Tights, who had been on the committee that drafted the exemption, wanted to make clear that it was never the intention of the General Assembly at that time to prohibit a member of the General Assembly from becoming a member of the Rhode Island Supreme Court without having to wait a year. I would just refer to his article, which is comprehensive and I would say highly persuasive. And I understand it's one representative, but the person who was one of the principal authors of the statute, and also who, I mean, for those of us who know of him, know the great esteem in which he has historically been held by attorneys and judges in Rhode Island. So I would encourage you to consider that as part of the broader picture of what was meant by this "or" in the exemption. And finally, I just want to say a word about the lack of any activity since the commission declined to adopt the advisory opinion in 2020. You know, there's a concept in the law, and I always refer back to my namesake, Thomas More, who, if you've ever seen or read A Man for All Seasons, you know the scene where he talks about, you know, he's being prosecuted for failing to sign these oaths of supremacy and acceptance of the king's new marriage. And he makes, and throughout all of his time of imprisonment, he never says a word about it. He never says he's opposed to it. He just doesn't sign it. And in the play, in the movie anyway, he makes this impassioned speech at the end, shortly before the sentence of execution is announced. He says, you know, I didn't say anything, and silence in the law implies assent. So the silence of the commission, of the General Assembly, of the judiciary, of anybody at all, from 2020 until today, to make any kind of an effort to amend the exemption, to otherwise somehow modify the law, to quote unquote clarify or change the rule about whether or not a sitting member of the assembly can seek appointment to the Supreme Court. And frankly, the lack of any complaints filed as a result of the appointment of a justice to the Supreme, a sitting senator to the Supreme Court, ought to be counted for something. It ought to be counted for silence, which I would suggest in the law implies assent. And that's why I think that what the commission did or didn't do in 2020 is entitled to weigh here, at least some weight here, in determining what all these interacting regulations and statutes and what the Constitution
This is
overrides.
a waste of time for the issue to come before us now.
I'm sorry.
Are you suggesting it's a waste of time for the commission to have this before us now and going into the future because of the silence since 2020?
I'm not sure I understand.
Well,
the question.
what is your purpose of saying that? You're saying that the silence does what? It doesn't change anything.
Exactly.
Wow.
Exactly.
What?
It leaves in place
What?
what happened in
It
2020.
does. Are you saying that that's it? We shouldn't be here today?
No, I'm saying you ought to consider that. That's all.
Oh,
I think it also means that you should consider reality
And
in a decision-making process.
we can let them get through their.
Okay, I
final comment.
apologize.
No problem. Let's just try to get through the final remarks and.
And just one more comment on the Inman case. If we were in the Supreme Court, which we're not, the prosecutor and I could debate whether or not the Supreme Court ought to be persuaded by the reasoning that Justice Silverstein, with the assent of the Ethics Commission, engaged in Inman. We could debate that in the Supreme Court, and they might say, well, no, we don't have to follow it, but we like it and we are going to follow it. But you do have to follow it, because the route of appeal from the Ethics Commission is to the Superior Court. That's the higher tribunal. And so I don't think you're free to disregard or rule differently from the reasoning underlying that decision, consistently with the structure that exists for
what decision are you talking about?
the Inman decision. So unless there are any further questions, I may rest.
Director Grant?
I'll just briefly respond to a few comments made. One as to the Constitution, the ability of the commission to rule on these constitutional issues. By all means, if you are convinced that something is unconstitutional, then what's in your power to address it? That's fine. I think you all understand that the point I'm making is that it's that ultimately it will be the judiciary who decides what's constitutional and what is not. And I would simply suggest to put a period at the end of this issue. Again, if you're convinced that it would be unconstitutional, that's one thing. If you've heard some interesting constitutional arguments, that's not a reason to find someone to dismiss this case. And I think respondents counsel. Regarding the 2000, I don't know if it was a commentary or an op-ed piece by Rep. Tights as to what the General Assembly, the entire General Assembly attended 30 years previously when he was a representative. But as again, to bring up a phrase from respondents counsel's brief, as any experienced appellate attorney knows, you don't look at post hoc rationalizations of former legislators. That's the proper term here. The court won't look at post hoc rationalizations of former legislators, even if under oath. So he could have submitted that by affidavit. And the court still wouldn't even consider it as to what the entire General Assembly intended 30 years previously. And the reason for that is because General Assembly has over 100 members. No one legislator knows why everyone voted on these things, just like you don't know what's in Commissioner Ritchie's heart when he casts his vote today and vice versa. So, I guess you can find it interesting, but if you do find that kind of thing interesting, and this case proceeds, I'll be happy to submit this weekend's op-ed piece by Phil West. And I know former Commissioner Mel Top probably loved to do an affidavit as to what the Ethics Commission intended in 1991 when it adopted the revolving door policy. As to the 2000 matter for then Senator, now Justice Lynch Prada, you know, interesting to say silence is assent, but I'm not aware of that being any legal maxim. And, you know, the commission is addressing, right? So now we have a case in controversy. Since 2000, there was 2001, excuse me, not 2000, 2020. Well, that would have, since 2020, no one, you know, now a case has been brought appropriately, and now you're addressing it. And let's address it, right? So no one tried to follow Senator Lynch Prada through that door until now. So now's the time. And listen, if this was a case against Justice Lynch Prada, that's a different argument as to reliance and, you know, what that might have meant. But today we're here in a situation where Representative Shekarchi is the respondent, and he was aware of what the commission did and didn't do. Maybe, I mean, we'll find that out. That's part of the investigation, right? So if we move forward, we're going to find out what Representative Shekarchi knew about the impact of the Lynch Prada decision. The fact that there was no Lynch Prada decision, right? Whether he was ever advised that he should seek an advice, all those things, that's all for a later date. And then you'll be able to decide what impact, if any, the commission's non-action in 2020 again, had to do today. Finally, just on Inman, again, this mischaracterizes my position. Follow Inman. Follow Inman. Great case. Wonderful. I used it myself when I wrote the Costantino advisory opinion in 2010, right? Inman is a fine case for you to follow. I'm not saying, and I'm not going to go to the Supreme Court and tell the court that they should disregard it. Take a look. Maybe they will find it persuasive. Notwithstanding Rule 18 now, the court can do what it wants. The court can suspend its rules anytime it wants to. So that's no problem. The point is, I'm not saying don't follow Inman. I'm saying Inman is completely different. It's completely distinguishable, and I'm not going to rehash the reasons why unless one of you asks me to. So I'll just close on those. Thank you.
Thank you, both parties, and it's clear your time and effort that's put into this. I think commissioners, we have a decision to make right now, and that is, do we want to go into executive session for deliberations or open session for deliberations?
I'd like to make a motion to go into executive session.
Do we have a second? Second? I didn't write that down.
Peterson and
We got it.
Browner. We have it. Peterson and Browner.
Thank you. Let's see, Commissioner Ritchie,
Yes.
Browner? Peterson?
Yes.
I think that's. Matt?
Aye.
All right,
And the acting chair votes aye. So that brings us to our executive session. Did you want to come back? Yeah.
I have to.
Yes. Give me a break.
I have to do it first.
Yes, we do. I think move over.
Okay, so are we moving into executive
Yes,
session?
You have to vote.
I have to do some announcement first, remember?
We'll have to vote for executive session.
We voted to put that into the executive session.
Yes.
Yeah,
We still have.
That's fine.
So the next question is whether there is. When I do it, well, no, the next question. Where's the, I got, no, I can't read it. On the agenda, the next question, the next item on the agenda is a motion to go into executive session to wit. A motion to approve minutes of the executive session held on June 2, 2026 pursuant to RI Gen Law Section 42-46-5A2 and 4. The just voted on In Re K. Joseph Shekarchi complaint on 826-1 pursuant to RI Gen Law Section 42-46-5A2 and 4. Item C on the agenda for the executive session is annual discussion and review Ray Legal Counsel's contract pursuant to RI Gen Law Section 42-46-5. A1, and the last item on the executive session agenda is a motion to return to open session. I want to put out now that based on discussion I've had with Mr. DeSimone and with the executive director, we are going to postpone item 4 on the executive session. We will continue the question of legal counsel's contract to the next session. So the only matters that will be considered in the executive session will be the motion to approve the minutes, the Shikarchi matter, which I will recuse on, and the motion to return to open session. Yeah. So is there a motion to go into executive session?
So moved.
Motion by Commissioner Callahan, second by Commissioner Peterson. Roll call vote. Commissioner Susie.
Aye.
Mr. Peterson. Mr. Browner. Aye. Mr. Callahan.
Aye.
Senarini.
Aye.
Mr. Ritchie.
Aye.
Mr. Strauss. Aye. And the chair votes aye. I'm going to executive session.
Mr. Chair, if I could just mention that we have a large online audience, and for their benefit, I would just like to explain that the live stream is going to end during their executive session, but when that's over, we will reconvene in open session where the discussion and any votes that need to be taken will continue, and if so, you'll be able to get back into this meeting at that time. Thank you.
Thank you.